Good morning, everyone. Very first ever DDR's graduation ceremony by ADR ODR International. On behalf of Team AOI, I'd like to say that we're truly grateful for your presence today. This room is filled with individuals from different parts of the world, and it is an honor to celebrate this occasion with you. Before we begin, I'd like to take a moment to explain the flow of today's ceremony. In just a few moments, we will commence with the faculty session, which Minister of Ceremonies will declare the ceremony officially. We will then proceed according to the agenda outlined in the placed on your seats. To our graduates, please take note of a few important guidelines. When it is your turn to receive your award, the ushers will guide you. Please follow their instructions. As you walk to the stage, you will first meet Rahim Shamji, our head of faculty. You may choose to shake hands with him or place your hand over your chest if you prefer not to. You will then proceed to Lord Newberger, who will present you with your DDRS letter. Please pause for a moment to ensure your photograph is taken before moving forward. Finally, you will meet Dr. Zoe Gianopoulos, where once again you have the option to shake hands or place your hand over your chest. You will then walk down the stage and follow the designated. Remain respectful and refrain from speaking or taking the microphone in the master of ceremonies. Once the to the families and friends who have supported our graduates, thank you. Your belief in them has played a vital role in this accomplishment. To our esteemed guests, we are deeply grateful for your presence today as we mark this historic occasion in the journey of ADR International. We hope you have a wonderful time celebrating with us today. And now, I kindly ask everyone to rise for the faculty procession. Thank you.
Thank you. Ladies and gentlemen, Lord Newberger, Abbott Green, Kelly Strickland, Peter Coutinho, and families and faculty members. Good morning and welcome. I hope you're all feeling very well today. It is an absolute privilege to stand before you here as the Master of Ceremonies for this momentous occasion. This is the first ever graduation ceremony for the Digital Dispute Resolution Specialist Diploma by ADR ODR International. This event is not just a celebration of academic achievements. It marks the beginning of a new era in dispute resolution. In a world that is rapidly transformed through digital technology, our graduates today stand at the forefront of change, equipped with the knowledge and expertise that will shape the future of conflict resolution worldwide. Now, we are gathered here today in an absolutely beautiful, historic, Great Central Hall in Westminster, a venue that has witnessed great moments in history. And today, it becomes another setting for another milestone. It is your graduation. It's a testament to your dedication and pursuit of excellence. Now, before we begin, I'd just like to take a very brief moment on my personal and just to reflect on my journey with ADR International. 9 years ago, I embarked on a journey with ADR International, not knowing how profoundly it would shape my career and my passion for mediation and dispute resolution. Over nearly a decade later, I've had the privilege of growing alongside this organisation, witnessing firsthand the evolution of alternative dispute resolution, the groundbreaking initiatives that have been introduced, and now this historic DDRS diploma graduation. I'm very privileged and proud to be standing here before you. Today, I stand before you not just as your Master of Ceremonies, but as someone who has been part of this transformative journey, watching ADR International empower professionals worldwide. To see all of you here, graduates who will be the next generation of dispute resolution leaders, is an incredibly proud moment. Because the high will go around and look for everyone. Now, none of this would have been possible without the visionary leadership of a very important person. At the helm of ADR International is a man whose dedication, innovation, and unwavering belief in the power of education to dispute resolution has brought us to this moment. This is Mr. Ravi Shakti, CEO of ADR International. He's not only an exceptional leader, but a true pioneer in the field. His mission to advance digital dispute resolution has transformed how we approach conflicts in an increasingly complex and legal and commercial world. You all have met him, and his excellence, his commitment to excellence, education, and the global legal community has shaped ADR International into what it is today. He is a leader in modern dispute resolution. So let us give a huge round of applause for him again. We're glad and careful to just come onto the stage to be all.
Make sure I got the speech ready. Lord Newberger of Abbotsbury, Miss Kelly Strickland Coutinho, my fellow ADR ODR International faculty members, President Noshad Jabraj, President of the Somali National Council, Sir Bernard Ricks, most importantly, graduates, soon to be graduates, distinguished guests, family and friends, good morning and welcome to the first ADRS graduation ceremony. I'm not even quite sure that this is even happening today. It feels completely surreal. In my address to you this morning, in addition to welcoming you here today, I'd like to share with you the vision of the DDRS diploma and make some exciting announcements on future projects of ADR ODR International and the DDRS diploma. First of all, let me introduce to you the faculty that sits here on stage. As I call your name, please rise. These are the most senior members of the ADR ODR faculty. Dr. Zoe Janapolo, Deputy Head of Faculty. She's Head of Negotiation and Mediation and runs her own institute in Greece, the European Institute for Conflict Resolution, and she also heads Greece and Cyprus. Dr. Khaled Hamid Chowdhury. Khaled is the head of international arbitration on the faculty, a mediator, and also the head of Bangladesh. Thank you, Khaled. Ms. Sarah Karan. Sarah heads AOI Pakistan and is also an international mediator, works with the World Bank, and also a very esteemed member of the ADR ODR faculty. You've already heard from her, but Ms. Anisha Punja. In addition to being a wonderful master of ceremonies, she's also the head of Mauritius and a mediation trainer. And like Zoe and Anisha, who have been there from day one, and I would say -1, before the inception of ADR. Next to her is Ms. Sofia Giannapoulou. Sophia is head of France, Belgium, and Luxembourg, also an international mediator and mediation trainer, and a very, very valuable member of the faculty. Thank you, Sophia. Moving on, not last but not least, Namita Shah. Namita is our newest member of the faculty and head of artificial intelligence in online dispute resolution, has designed a wonderful course for us, and is also the co-founder of Resolve 360, one of the largest ODR platforms in the world, and she's done it tremendously with it as well. Thank you. To my faculty, each one of you, I'm very proud of all the efforts that you have made to travel around the world to be here for the first ceremony. Thank you for your trust in me, and thank you for believing in my crazy ideas. Most thank you for being on part of this incredible journey. I would also be remiss if I didn't acknowledge our resident representatives, and some of them are here in person, and some have joined us online. As I call your names, please stand up. We start with Gordon Ogolo Kenya. Our newest president representative is Victor Simone. Victor looks after Panama, Venezuela, and Spain. Thank you. From Israel, we have Rona Girat. Rona. And from Kazakhstan, Hassan Utubova. Thank you. And online, I'm going to shout out to Valeria de Souza Pinto from Brazil. One of our faculty members who couldn't be with us sadly today is AJ Jawad from India. Dipna Gunu, head of ADR Law. Angelique Juliet, the resident representative for Seychelles, and Mustafa Ahmed from Turkey. I will leave your hands the rest now. Thank you so much. So how did the DDRS diploma come into being? Well, between 2016 and 2020, I remember having many conversations with my colleagues, many of them sitting on the stage here, and Zoe and others about the use of technology in alternative dispute resolution. In fact, ODR, or the acronym, had become the buzzword around the market. We at ADR ODR International were the first to teach online mediation in the UK. We delivered the first multi-party arbitration in 2020 during lockdown. And I remember an arbitrator calling me saying, I've got a 10-party arbitration. What do I do? There's no venues available. And I spoke to the team and we all said, right, we can do this on Zoom. And we Zoomed a full arbitration. From there on, it has now been normal. It was very clear that a new way of thinking, the acquisition of new skills, and creating a new digitally friendly service and vocabulary was going to be critical to its success. In one of my presentations to law students in London, I said to would-be solicitors and barristers that you might become solicitors and barristers today, but tomorrow you need to become digital dispute resolution specialists. And as I said it, the acronym was born in my head. I left the presentation thinking that being DDRS was no longer a luxury, but a necessity. So during the unfortunate days of the 2020 lockdown, when I was tucked away in my aunt's outhouse delivering training, I began talking to my colleagues, and particularly Zoe, about creating a diploma. What was crucial, and still is, as these courses needed to have their own identity and status. We took the top 3 skills of alternative dispute resolution, negotiation, mediation, and arbitration, and made them mandatory units towards the DDRS qualification. We already had an ODR course, but that was simply teaching you how to use Zoom when we didn't know how to use Zoom and how to use breakout rooms. By 2023-24, and in a great conversation with Namita, all courtesy of Ruhi, who was speaking to you earlier, we met Namita and we began talking about artificial intelligence. And this is just when ChatGPT had launched. And she's like, we can do this and we can do that, and our platform is this exciting. And so we created this. We are now resident in 49 countries. In 2024, last year, we moved to a landmark relationship with recognition from the University of Lausanne, represented here today in the front row by Professor Andrea Bonomi. Thank you so much for coming. Professor Bonomi and Shahiza, who we should mention, who sadly can't be with us today, worked with ADR ODR to recognize the DDRS qualification as credits towards the CAS IBD, the Certificate of Advanced Studies in International Business Disputes, and Professor Bonomi will address you for a few minutes later today. In addition, I'm very proud to announce today that Leeds Law School will be recognizing the DDRS diploma also towards LLM credits in a new LLM in digital dispute resolution. The new LLM will give graduates around the world opportunities to upgrade their qualifications to master's levels, and I want to give sincere thanks to Deborah Caps, who again is in Paris. He said he's stuck in Paris, I don't believe me. He's probably having a good time. Who was very instrumental in helping us reach this milestone. Both of the University of Lausanne and Leeds School offer graduates a choice in their digital dispute resolution journeys. And to both of these, I say that we are now going to create a new benchmark in legal training that if you're not a DDRS, you may not have all the skills that you need for the future. I'm also delighted to announce that ADR ODR International has signed an agreement to work with Presolve 360 to create a tech and ADR organization collaboration where we start to create opportunities around the world. Namita, thank you to you and your 2 co-founders, Aman and Bhavan, and we look forward to working with you closely. Since our inception, we have trained 5,000 people in mediation, arbitration, negotiation, and online dispute resolution. To date, 250 have successfully earned the title and qualification DDRs. So many of them can't be here today for various reasons, travel, visa, etc. But we are looking to host ceremonies, if you're watching online, in your neighborhood very soon. To our graduates who've been able to make the journey to London, we represent 15 countries and come from a diversity of backgrounds that would make an organization like the United Nations very jealous. What you have in common is you have the best skills and training to be the best mediators, arbitrators, negotiators, and AI specialists. To each of you in the room or watching online, many, many congratulations to you and your loved ones in supporting you to undertake this diploma. Many of you who are here took these courses online at local times that were the middle of the night for you. Many of you managed to do this without even yawning. You are here because of your dedicated notion of peace and ADR. You came to learn, but as a faculty, we learn from you, from each one of you. Your energy was infectious, your commitment admirable, and your ideas were full of hope and stellar. So now you have the qualifications. What are you going to do with them? For most of you, this knowledge will add tools to your toolbox and will hopefully lead to a better, qualified, relevant leaders in the sector. The legal profession is facing existential crises with the rise of artificial intelligence and alternative dispute resolution. I urge you as graduates to help your colleagues, your firms, your organizations to understand the scale of the challenges ahead and to ensure that you all have the tools of DDRS in your toolbox. As we look around the world is going through several issues from geopolitical perspective, as well as the overloaded and burdening court systems. I have been wondering for some time how you and I can play a role in these challenging times. The answer is not one-size-fits-all approach. We tried that with the common room. When we think there is a unique answer, we end up with major problems, and one of those which is close to my heart, if we ignore culture, we ignore humanity. Understanding culture and respecting it is not easy. I'd like to take a quote from late Highness the Aga Khan IV, Prince Karim Aga Khan, who sadly passed away on the 4th of February this year. And it's been an inspiration to me in the peacemaking space. At the opening of the Aga Khan Centre in King's Cross, London, in June 2018, only a few months from here, he said, I quote, "One of the central challenges that our world faces today is the challenge of harmonizing mainly highly diversified voices with an increasingly globalized world. I use the word harmonizing carefully, for our ideal here is not to create a chorus that sings in unison, but one that blends many distinctive voices into an intelligent, resonant whole. But to do that requires a deep understanding of what makes each voice distinctive. You may have the same qualification and skills, but your job is to harmonize the knowledge carefully in each of your respective jurisdictions. What works in London may not work in Delhi or Islamabad. What works in Dhaka may not work in Nairobi or Bangkok. Each of your voices, your skills are unique, and I hope and pray much success in your professional lives. Our calling is to empower citizens to use ADR methods that are culturally relevant and has peacemaking at the heart of it. A pluralistic notion of resolving disputes is a good one. Now I'll say a few words about our two keynote speakers and guests. I'm delighted to welcome Lord Neuberger and Ms. Ellie Strickland-Rottini. Lord Neuberger graduated with a degree in natural science from Oxford and worked at a merchant bank until he entered Lincoln's Inn when he was called to the English bar in 1974. He specialized in property law and was appointed Queen's Counsel in 1987 and became a bencher of Lincoln's Inn in 1993. From 1996 to 2004, he served as a judge in the Chancery Division of the High Court, where he was appointed Lord Justice of Appeal in 2004 and Lord of Appeal in Ordinary in 2007. He became Master of the Rolls in 2009 and in 2012 was appointed President of the Supreme Court of the United Kingdom. He retired from that post in 2017. He has since been practicing as an arbitrator, mediator, and legal expert from One Essex Court. He became a non-permanent judge of the Court of Appeal, of the Final Appeal in 2009, and a judge of the Singapore International Commercial Court in 2018, and continues to sit in both courts. Lord Newburgh was Treasurer of Lincoln's Inn in 2017, and elected Honorary Fellow of the Royal Society in the same year. He's an honorary member of the Royal Institution of Chartered Surveyors, and he was appointed Chancellor of the University of Law in 2018. He received doctorates from UCL, Queen Mary London, York, Exeter, and Oxford. He's president of the British Institute of International and Comparative Law and the Academy of Excellence. He's also a trustee of Prisoners Aboard and Mental Health Research UK and the patron of SIGA. Our second speaker, Kelly Strickland Coutinho, is the chair of the Civil Mediation Council. She's a mediator and a barrister of 39 Essex Chambers, appointed as a member of the Civil Procedure Rules Committee, which makes the rules of the Court of the Civil Division of the Court of Appeal, the High Court, and the County Court. She's appointed a CEDARS panel of mediators and Sports Resolutions panel of mediators and arbitrators. She acts in commercial disputes, including international disputes, financial services disputes, commercial public disputes, and high-value tax disputes. Most notably, she was counsel in the landmark case of Churchill and Merthyr Tydfil, in which she represented the CMC, CEDAR, and CIR, led by Edwin Glasgow KC. And I was in court, Kelly, watching all the proceedings on the first day. Shortly, I would invite Lord Newburgh to come and address us, but I have the first of my privileged tasks as being the head of faculty to confer and award the title DDRS Honoris Causa to Lord Newburgh. Lord Newburgh, from my time as a junior barrister, I've been following your illustrious career on the bench, and since leaving the bench, you have been one filled with peaceworking in the most difficult cases. We're delighted that you accepted our invitation to come and address the graduation ceremony, but more importantly, to accept our first honorary DDRS award. May I ask Lord Newburgh to rise and Dr. Zoe Giannopolo and I to come and present you the award of DDRS. Ladies and gentlemen, before I sit down, I'd like to acknowledge a few partners. Today we have EPP Law School, we have the University of Law, we have the University of West England, who have all been incredible partners on the journey for ADR ODR International. But before I leave you, and before I get in trouble, I want to acknowledge my family who are in the front row today. Without you, this wouldn't. Thank you. Congratulations.
Thank you. So I'd now like to introduce our first keynote speaker to take the stand, Lord Newburgh.
First of all, I'd like to thank you very much for the great honour being an honorary DDRS diplomatists and being the first one. Thank you very much indeed. I'd also like to begin by congratulating those who've actually had to work for this diploma and say what a very valuable diploma it is and what a very valuable activity you will be indulging in as a result. I wish you all well, that you will succeed in what is both worthwhile job from the point of view of the public and a worthwhile job from the point of view of people involved in disputes. As you will have heard, I became a judge in 1996, and I stepped down because I reached the magic age of 70 in 2017. Looking back in 2017, I thought that there were three big developments occurred since I became a judge. One was the introduction of the Human Rights Act and the introduction of human rights into our law. The second was the effect of IT in its broadest sense. The year after I became a judge, in 1997, we first became aware of artificial intelligence when Deep Blue, developed by IBM, defeated at chess the world champion, Garry Kasparov. And that brought to our attention artificial intelligence. As you will know, things have developed since then. And the third big change was alternative dispute resolution. It started before I became a judge in 1996. Most practicing lawyers, including me, not really aware of it. During my career as a judge, it was my role, of course, to help implement and apply human rights law into our law. And as I became a senior judge, it became my role not merely to use IT, but to try and ensure that IT was appropriately used in litigation and indeed in legal practice. And so far as dispute resolution is concerned, I found myself in a rather strange position of pontificating about the values and importance of mediation and early neutral evaluation and other forms of ADR without having had any experience of it. Fortunately, since I stopped being a judge, I have become involved in mediation and arbitration, as you mentioned. I suppose the biggest change since I retired has been the problems faced by the rule of law both at home and abroad. But I don't dwell on those today, but merely mention that it makes the function which you graduates, which you DDRS diplomatists make all the more important because the role of ADR and ODR in upholding the rule of law are very important. First of all, there is the fact that not merely in this country, but in most other countries, litigation is a problem. And the reason it's a problem is partly because, particularly in our common law system, we go into cases in great detail in order to do justice. We have masses of documents that have to be looked at. We have detailed cross-examination, which is all very creditable in terms of getting to the right result and digging deep, but is very expensive, causes delay, and delay and expense, even worse, cause a lot of stress to individuals involved. But it also means for the ordinary small cases, they are disproportionately expensive. Realistically, if you have a claim of £5,000 against a plumber who is claiming £5,000 from you, going to court and having it dealt with properly as we common lawyers used to see it, would cost each side at least £20,000, which is absurd. The way to deal with it is to find some other mechanism of dispute resolution, and that is what's developed over the past few years. And of course, we have to face the fact that A, litigation does not produce always the right result. With the best will in the world, judges and arbitrators don't always get it right. And even if they do get it right, there is often no obviously right answer. There's a range of possible answers. And in many cases, who you believe or don't believe is a matter of difference between different people, have different perceptions of who's honest. And when it even comes to the law, there can be different views of the law. We have to face the fact that very often there is no right answer. And to that extent, having a quick answer it is not necessarily as detailed in its examination of facts and law, is almost as likely to produce the right results in many cases as a very thorough examination. Secondly, there is the fact that even if litigation will produce the right results more often than a quick resolution, if litigation is going to cost a great deal of money and take a great deal of time, there's a question of whether you'd be better off with a quick decision rather than a slow decision. And thirdly, there is the point that litigation and arbitration are prohibited. Many disputes involve issues between the parties that a judge or arbitrator can't determine. A judge or arbitrator, save in exceptional types of cases, can't get people to apologize, can't get people to give the other party something which the law can't give them, but which, if they are engaged in mediation can give them. It may be that in a dispute between neighbours, for example, the law has to decide where the boundary between two properties is, and that's all it can do. But it may be that if the two neighbours get together, they can agree that even though the boundary has to be in one place or another, they can find a little way, or they can find a little bit of land that the one party wants and the other as a way of solving the dispute. Also, in many cases, people have to live together, whether they're neighbours, whether they're husband and wife or ex-husband and wife, whether they are landlord and tenant, whether they are in a long-term business relation. We can sort out claims between them in a friendly basis. That's much more satisfactory than forcing them into a long-term argument where one of them is a loser and will never forget it. All these are, of course, good reasons for dispute resolution on a more informal, on a more relaxed, on a cheaper, on a quicker basis. But it requires human nature being what it is. People who can act as mediators, people who can bring people together. It may be a sad comment on human nature that mediators are needed, but it be equally a sad fact that judges and arbitrators are needed. And if they're needed, then it's vital that they perform their duties in the best way possible. And it's a very demanding job these days, because partly life is more complicated, rules are more complicated, people are more sensitive, and of course there is the added factor of IT. We don't know where IT will take us. As has been said, it is quite possible from Raheem, from what Raheem has said, it's quite possible that AI in the long term presents an existential threat to the whole litigation world. I gave a speech last night about that. I think that if you have to rank the various jobs which lawyers have, judges and arbitrators are probably the most exposed to replacement by AI. Practicing lawyers come second, and mediators probably in the strongest position, because the sort of function that mediators provide involve a lot of human emotion, a lot of what you might call illogical, but principled and above all emotional qualities, which are going to be most difficult, if not impossible, for AI to mimic. So to that extent, it can be said that you're not only embarking on a very worthwhile exercise in becoming expert mediators and ODR, dispute resolvers, but you're also doing yourself a favor, because if AI is going to replace you, it's going to take longer than replacing you in the other. In predicting that the AI might achieve this, I would end by making two consoling thoughts. The first is that it's by no means sure that AI will replace lawyers. The second is looking back 200 years to the Luddites, who were textile workers whose jobs were threatened in the early 19th century by new machinery and new technology. They rioted and destroyed the new machines. Ultimately, they failed, and progress triumphed. And they were right, they lost their jobs. But they found pretty quickly that the technology they objected to resulted in new unexpected jobs that were actually better paid. So even if we are replaced by AI, we may find new unexpected jobs, but the more different experiences, the more different qualities, the more different qualifications we have, the more likely we are to be well prepared for new jobs. And by immersing yourself in artificial intelligence, in IT, in ODR, you are undoubtedly also helping yourself for the longer term future in finding roles for yourselves. So both because you're acting in public interest as well as citizens' interest, and because you are doing a good job for yourself, and you are acting, I think, in the public interest. Congratulations to all of you. Thank you very much, and all the very best.
Thank you, Lord Newberger. I hope you all found that very enjoyable and insightful. You can see Newberg's in valuable experiences had over many years. More like it's my takeaways, I think, that would be, let's hope that mediators, lawyers, and judges can work in partnership with AI, and we can all have a job and work in collaboration together. I think with mediation, it's a process where you need to put the power back and give the power back to the parties, and that's something that we need to educate members around the world. So with no further ado, I really want to just go back into introducing our next keynote speaker as well. We're very privileged to have her here today, and we're going to give a short introduction about Kelly. What we'd really like to hear about is a little bit your case that you dealt with the Church Volunteer Law. And with no further ado, I'd like you just to take the turn.
Thank you so much for having me. It's a really great pleasure to have been asked to give an address for this, the first graduation ceremony for TTRS. And may I start by congratulating you on taking your next steps in this profession, and particularly for doing so at a moment that really could not be a better one to be a dispute resolution specialist. I'm going to spend a few minutes telling you why I think this is a particularly special moment to be taking those steps. And I hope that I can show you what I regard to be one of the hallmarks of this industry, which is that we mediators innovate and we take ownership of our own field. I am going to focus on developments of mediation, and I do want to be clear that to be a good mediator today, that really means understanding the context of being a mediator. And an essential part, to my mind, of being a dispute resolution specialist is understanding how many methods of dispute resolution can work together to benefit their users. So the UK has historically, I think, been at the forefront, very forefront, of the development of mediation, with some of our most senior mediators in the UK having founded the key organisations, having developed international legislation, and having established the UK as a key jurisdiction for mediation, in particular of commercial disputes, whether international or domestic. I'm not satisfied with having led those developments. Many of our senior mediators have gone on to develop even more innovative ways of using mediation. That's a topic I'm going to return to later. Having led that work to establish mediation as an important way of resolving disputes, the UK then experienced something of a slowing down following a case in 2004, Halsey and Milton Keynes. And in that case, it was decided that requiring unwilling parties to mediate would be an unacceptable obstruction of their rights of access to court, or in other words, an interference with our substantive rights. And it took nearly 20 years for that principle to come back to the courts. It's very embarrassing talking about one's own cases, but expressing the answer to it, so I shall for a moment. When this case came back to the courts, it's Churchill and Tyndall. It came back before a special constitution, related Chief Justice, Master of the Rolls, and Justice Third, his deputy head of civil justice. As it happens, when we were working on the case, we had been told quite early who our listing was. And I'm afraid to tell you that somebody in my chambers described us as speeding downhill, which was perhaps unkind but probably correct in the sense that a constitution like that, one can expect particular outcomes, I suppose. Perhaps appropriately for the significance of the case, it also involved a number of interveners, the Bar Council, the Law Society, and as has been mentioned, the Civil Mediation Council, CEDA, and CIR, together represented the voice of the mediation sector as well as housing bodies. And I should highlight that leading mediators in the UK were also part of those legal teams. Michelle Campanitas, Spacey, as has been mentioned, Edwin Glasgow, who I was lucky enough to be junior, and Ian Gatt, Silver, who is interrupting us. And frankly, without those mediators being there in court to give a real perspective of mediation, in my view, church wouldn't quite have happened in the way it did. Perhaps unsurprisingly, this case has been described as a game changer. And ultimately, the court held that a court could order unwilling parties to use ADR, provided the order didn't impair the very essence of the right to a fair trial, was made in pursuit of legitimate aim and was proportionate. That judgment, to be clear, represents a fundamental shift. A shift so fundamental that when it was implemented into the civil procedure rules, it was inserted into the overriding objective, so that the overriding objective now includes the power of the court to order or encourage parties to use ADR and requires the court to promote or use ADR. And that change, very significantly, was backed up by a sanction with failure to comply with an order or unreasonably failing to engage with ADR. To my mind, that is an absolutely essential provision to ensure a change in behaviour with those who might otherwise be reluctant to consider ADR. And those rules have since been reinforced in specialist tracks, but most recently in the commercial courts, those rules shortly coming into force. And that's not all hot on the heels of Churchill, or perhaps more accurately on a twin track Churchill, was the UK's pilot scheme for automatic mediations, the money claims valued up to £10,000. That's now been operating for some time. It has a success rate which is comparable to the rates of other automatic referral schemes in other countries, roughly 50%, and a notably quick turnaround. There probably hasn't been enough time yet to know what the impact of that is on that. But it is clear that it is leading to quicker resolution and for those claims which succeed at mediation. And the Ministry of Justice hasn't ruled out further developments in this matter in relation to higher value claims. It is fair, I think, to reflect that many other countries have had automatic referral before the UK, and in some ways the UK, because of the principal palsy, perhaps a little behind. But the UK is now making great strides in developing how we do those things, and there's much more to be done. All of these changes are fundamental, and they are undoubtedly the biggest changes to the use of ADR in the UK in over 20 years. And really, they amount to placing ADR at the heart of strategy decisions in disputes. So why are all of these important developments happening now? Well, we have the most senior judiciary in England and Wales firmly behind it and in support of promoting the UK as a leading global centre for dispute resolution. And we at CMC, with our partners, are leading a group which has been called for by the Lady Chief Justice to establish a London dispute resolution committee. And the aim of that group is to bring together litigation, arbitration, and mediation, and to demonstrate that the UK is a leading global centre for dispute resolution. That work is very much in its early stages, but for our parts at least, we think it's right that these three disciplines should look at how we can work together to the best advantage of users. And what does that mean for us as practitioners? Well, it means that presenting the UK as a jurisdiction in which one can go to resolve any kind of dispute in any way. So I hope you'll see that the UK, at least in mediation, is taking its new place in the civil justice system. And I would say it's rightful place. An essential part of that new role is demonstrating to users of mediation that mediation is a safe process. And that means developing and building on the standards that our mediators are held. The credentials that a mediator holds are a crucial part of that. So I suspect those of you who have graduated today will really feel that to be true. We at PMC require that our members hold what we regard as a baseline requirement of appropriate training qualification, training courses for which we set standards and moderate the requirement to hold insurance, complaints process, continuing professional development, and to demonstrate recent experience. But we also hold our members to those rules that disciplinary process. And perhaps in a theme for our sector, we're not resting on our baseline, and we continue to develop enhanced standards, particularly, for example, community mediation, which is absolutely fundamental to deep societal conflict, and we're also acting in other areas like workplace employment, SEND peer mediation, which is mediation between children in schools, how incredibly powerful is that, supporting the development of mediation as an academic discipline. And I think it's important to say we regard our relationships with our international friends as essential. In the modern world, many of our mediators are mobile, and one of the challenges that we're actively working on is how we can find equivalence or mutual recognition in key jurisdictions. And to my mind, that is also very important in demonstrating preeminence of the UK as a jurisdiction. The final point that I will touch on is another area which represents an opportunity is, of course, the use of AI and the wider use of digital technologies in mediation. I think it's enough for me to say at the moment that these must be supported. There are so many ways in which mediation can work so much more smoothly with technology, but we must also recognise that at heart, mediation is a system fantasy. Like tech can be very helpful in supporting the mediation, but our skills as humans will always be needed to. I'm pleased to say that I'm really thinking about that. To my mind, the very essence of being a mediator is to be human, it's to see people, it's to see what matters to them and why, and to help them to come to an outcome that is just for them, taking into account all the circumstances. Tech can no doubt help everyone involved in mediation to do a better job, but it is ultimately a human skill. And I said that I would turn back to current work of some of our leading mediators in the UK. So I just want to rest on these last points. Many of the mediators that I talked about earlier are now mediating our very hardest cases and using their skills outside of the traditional course. In the last year alone, there's been very important work mediating with things like junior doctor strikes and the disputes with the British Medical Association, which had a deep impact on society. I am going to mention that, of course, that we'll be working along with Bill Marsh and Anna Howe to be mediating the Grenfell Tower disputes. Again, very significant for exactly those key issues that it's dealing with. And the UK's mediators using their skills even more broadly in peace building on the international stage also. So there is no doubt that the UK has been and continues to be at the forefront of development of mediation. And as I say, it is an essential part of the UK's offering as a global central dispute resolution. So I have a call to action for those of you who are graduating today, and it's this. Mediation is developed in the UK because its mediators have been advocates for its use and have made it their own. Developments that I've talked about can all be attributed to mediators taking the development of mediation into their own hands. And so I would like each one of you to think about what you can do to innovate, to move mediation forward, and to take mediation into your hands. Because the development of the profession, particularly the future of the profession, is as much in your hands as it is in mine. I very much look forward to seeing what this generation of dispute resolvers develops.
Thank you, Kelly. That was most insightful. So our graduates, they have a call to action, and I hope that you'll be able to fill this role and see how you can develop mediation in your own home countries and also with your partner neighbouring countries as well. With no further ado, we're coming towards now the most exciting part of the day, I think, the graduation ball. So this will start with our graduates who will take the stage, and they will then be greeted by Ms. Rahim Shamji, Zoe, and Lord Neuberger. And if they could greet Rahim, take a scroll from Lord Neuberger and greet Zoe, and then have a photo of them on the stage, that would be great. And then afterwards, we're very lucky, we also have a presentation to our faculty members. So DDRS is actually quite unique because all of our faculty members sitting on the stage today have also undertaken the diploma, and we're very proud to be sitting here and to also accept the award as well. So that will happen shortly afterwards. So with no further ado, I can invite our awarding panel to the stage. Lord Neuberger, over to you to come over. Good, I think we're ready. Is our graduates in line ready? Lovely. If I can call up to the stage Colin, Gordon Oberlin. I'll now call up Rona Janae. Asel Atapova. Victor Simone. Aruna Verma. Sophia Zakia. Anastasia Boretsky. Ruby Leila Vinod Thacker. Abhishek Pala. Marisha Khan Abia. Ioannis Atlas. Aku Adagon Adu. Asha Adagon. Malala Asu. Wasika Wasika Amen. Richard Michael Clam. Kirsty Cowan. Baristi Akadu. Christina Evans. Maria Veronica Ferroza. Elizabeth Mimi Ozier. Joanne Holland. Samir Iqbal. Amelia Kaladaiti. Upa Smeta. Gina D. Donne Oclu.
Yeah.
Chinaza Okoroma. Nasrit Naveen. Mohammed Altaf Jafar Qureshi. Sylvia Reddy. Bernie Saka. Christian Shankar. Aveen Siva. Laura Tweedy. Tabia Williams. Thank you. So now we're going to turn to our faculty members to receive their award. It shows that they are also on a lifelong journey of learning about need creation and dispute resolutions, and congratulate each of our faculty members. I'd like to start the session with Dr. Ferry Gianapolo. Dr. Khalid Hamid Chowdhury. Sarah Torara. Gia present. Namita Shah. Looking at my Kelly Strickland team.
And let's not forget our beloved MC for today, Anisha Bhujan.
Thank you. So I'd like to now just introduce one final important guest speaker. And I'd like to invite onto the stage Professor Andrea Bonami.
Tanisha, dear Team Shanji, dear Hima, dear faculty members, Shinya, it's really a big privilege to be here. I'm very grateful to Rahim for inviting me and giving me the opportunity to share with all of you this very beautiful moment and this impressive celebration. Graduation ceremonies are always the best part of a professor's life. In this case, I don't have any credits because I was not involved in the program. So it's pure pleasure without any work behind. I didn't really prepare a speech. I didn't know that I would be given the possibility of addressing you today. So I just want to say some words out of my heart, which were inspired by everything what I've heard before. I think, first of all, I would like to really warmly congratulate all graduates for your achievements, but also for the choice that you have made. I think that combining alternative dispute resolution mechanism with technology and artificial intelligence and all these new amazing possibilities that we have is certainly a very good choice for the future, and the choice not only professional choice, but the choice I would say philosophical choice, a choice for hope, a choice for hope in a world that is still very much influenced, unfortunately, by fight, by threats, by retaliations, and so on. I think that choosing alternative dispute resolution is certainly a choice for peace, a choice for tolerance, and this is something very important apart from all the practical advantages that these mechanisms have in the practical life of parties involved in the disputes. And of course, technology is something that offers us today amazing possibilities. It's also a little bit scary, perhaps, to a certain extent, in particular for old-fashioned lawyers as I am. But for young lawyers as you are, I think it's really the good choice to do. And I think it's important to look at this new possibility with a lot of hope and optimism for the future. So I congratulate you. I also envy you a little bit because while I specialize in private international law, in international litigation, in international arbitration, but I think that if I were your age, probably I would try to more specialize in mediation and with other techniques. Of course, it's not too late. Perhaps I see that faculty members also take the diploma, so perhaps I will be here in the future to take the diploma if I'm allowed. I was invited here in particular to say some words about the new cooperations that we have created together with Rahim. Rahim is teaching since several years in our LLM program in International Business Law, a program of the University of Lausanne, and we are all appreciating a lot his teaching, his inspiring teaching. Of course, the organizer of the program, I'm one of the directors of the programs, but also in particular the students and the participants. We have one of the students here, Christina Evans, who also took the DRS diploma. So we were very happy to have him for so many years, but we decided recently to take this cooperation a step forward, even two steps forward to an extent. What does it mean? First, we have decided to combine this very new and visionary DRS program that Rahim has invented and created with a certification that we have at the University of Lausanne, Certificate in Advanced Studies, which is an academic certification. And so it is possible now to register jointly with for these two diploma and with the same courses to get, in fact, both the DRS accreditation, the DRS diploma, and the university diploma CAS in International Business Institutes of the University of Lausanne. What is the advantage of this? Well, the courses are the same, basically. But what is interesting is that you can get an academic diploma, an academic degree, which can also be recognized for academic purposes. And this is possible not only for newcomers, but also for all of you that have already attended and finalized the DDRS. It's possible to register now for the CAS IBD with an additional course and a very limited additional fee to get also this academic diploma. What is the advantage of this is the possibility also to have all this effort that you've made credited for academic purposes and also to be recognized for the purpose of our LLM in international business law. So if you have the admission condition for an LLM, it's possible to register for the LLM and then you can take with you your credits that you have already acquired for the DDRS and complete an LLM program. Why acquiring an LLM program in Switzerland or in Lausanne? Well, I think there are several good reasons to do that. One good reason is that, well, when you talk about dispute resolution and mediation, etc., it's also a matter of culture, of sharing different cultures. Many of you come from different countries. Switzerland has a longer tradition as an important arbitration hub, but also a very important tradition in conciliation, in mediation. It was one of the first countries in Europe to encourage conciliation, mandatory conciliation for before court proceedings, also outside of court proceedings. There are very interesting mediation possibilities. So I think it's interesting also to take some steps towards knowing the Swiss experience. Our LLM program offers you the possibility to explore other new areas. We have interesting specialization, of course, dispute resolution, but you are already an expert in that. But we have also specialization in innovation law. We have a specialization in sports law. You know that Lausanne is the Olympic capital, the seat of the IOC, the seat of the Court of Arbitration for Sports, and of many international federations. So we are in the middle there, and we have the sports law courses that are very interesting for that. We have specialization in climate change, which can be very interestingly combined with litigation, mediation, and so on. So the courses are certainly very diverse and interesting. We have a very rich faculty composed of academicians, but also a lot of practitioners, professionals, experts from different countries. The students are also from very different countries and with different background experience. We offer all the courses in Lausanne. Lausanne is a very nice location on the side of the lake of Geneva. We could call it the Lake of Lausanne. Lausanne is really in the middle of the lake. It's a very beautiful campus. But if you cannot come to Lausanne, you can also attend these courses online. Courses. And I think there are many different good reasons, and I really hope that we perhaps we can share in some time, some months or some year, another graduation ceremony with some of you in Thank you for having me, and congratulations to everyone.
Thank you very much, Professor. And now I would just like to, before we close, I want to invite Rahim Shamji back onto the stage. He has something very special he'd like to share with all of you graduates and our family members and our esteemed guests. So please welcome Rahim back onto the stage.
So, ladies and gentlemen, when I was planning the graduation ceremony, and very honored to offer Lord Neuberger an honorary title, I thought it was very appropriate to also think about a Lifetime Achievement Award. And so it's been quite difficult to keep this a secret, but I think I've managed from the person who's going to receive this. So today is the start of this new award for the architects of ADR and ODR involved in peacemaking and has undertaken remarkable progress in the countries or sectors which have moved the needle so far forward that this progress must be recognized. And the title, of course, is the Lifetime Achievement. And today's recipient is someone many of us know very well and have undertaken most remarkable progress in her home country and around the world. We had to keep it a secret because if we told her, she's so humble, she'd say, I don't want it. So I'm going to announce her name first, and then I'm going to say why she is the recipient. So please give a round of applause to Dr. Zoe Jones-Boyd. Thank you. Let me say why she's deserving of this as well. Zoe began her journey reading law at Aristotle University in Greece and went on to obtain her LLM and PhD in European economic interests. She stumbled, as she says it, upon ADR in the European Directive as part of her PhD research. In 2011, Zoe qualified as an accredited mediator here in the UK, as well as attending Harvard University in 2013. She was the deputy chair of the mediation committee by the Greek Ministry of Justice. She was led by the late Professor Koutsiris, who we all mourn the loss of, and his immense wisdom. From 2013 to today, Zoe has pushed the agenda for mediation and ADR in Greece like no other. From trainer to lobbyist, assessor, leader, and now Greece's appointed mediator and facilitator to ICSID. In 2014, rebooting the directive was a report written by Giuseppe De Paolo, and Greece was ranked the lowest country for mediation in the 28 member states of the EU then. Now it's 27, as we all know. But you'll be proud to know that Greece has risen from last place to second place in the most number of mediation. Since 2011, when Zoe first became an accredited mediator, she has been on a mission to make Greece embrace mediation. Her commitment to peacemaking and helping people of Greece to find peaceful resolution has been incredible and humbling. Her tireless efforts to navigate the local stakeholders in Greece in such a way as to not alienate each of them. On a personal note, Zoe, without being on paper, is like a co-founder to ADR ODR International. She's been there every step of the way as we have managed opportunities and obstacles of working in this space. Since 2013, Zoe and I have trained over 700 mediators in Greece, although just over 40% of the mediators in Greece. I have been there for most of the courses, but not for all the days. Zoe has been there throughout. From training, developing, to the new mediation law, to writing the main textbook in Greek on mediation, Zoe is considered to be a national treasure in Greece. If you need to find a friend, call Zoe. If you're stuck in Greece. Greece and ADR ODR International and myself owe a huge debt of gratitude to Zoe for her exceptional work in bringing mediation to Greece and developing the next generation of peacemakers. Every member of the AOI team, past and present, has been and is in awe of you and always look forward to learning from you and sharing their journeys with you. Please join me in celebrating and applauding the first recipient of the AOI Lifetime Achievement Award, Dr. Zoe Jani. Zoe would like to say a few words, but she's also listed to give the vote of thanks. So I'm done. I mean, you can come and take over. Let me just find your.
I prepared so much in the future guys, truly. And I have no words actually. I'm deeply touched. I accept good gratitude. And it's been an honor, a privilege, a blessing to be sharing this amazing journey you have seen. My dear friend, colleague, mentor, a visionary. And I believe this is a milestone of many more that we follow in the future. God bless you. And I'm grateful to many people here. Thank you for inviting my sons, Constantinos and Alexis, who didn't know they would come, and to my sister for supporting me and inspiring me while I was serving as a peacemaker around the world. I was away from them. Thank you so much, and thank you to all our friends, colleagues, and peacemakers who share the same vision as we do. And now we go to my formal speech. Yes. So, Lord Neuberger, Miss Kelly Strickling Kutunko, my fellow ADR International Faculty members, distinguished guests, most importantly, newly graduated DDRS graduates, family and friends. Good morning to all of you. I'm delighted to be asked to give a vote of thanks and officially to close this inaugural graduation ceremony.
May I begin by, first of all, offering my sincere and heartfelt congratulations to all the graduates today. Your incredible dedication towards dispute resolution is a testament of your openness to learn, create peace, and support society in moving from conflict to peace. This has been my calling, like all my colleagues here on stage and our global team. So bravo to each and every one of you. In order of significance, I would like to offer thanks to the following groups and individuals. My first thanks to our keynote speakers, Lord Neuberger. Your wise words have given us all of much food for thought, and especially the graduates as they embark on their careers in dispute resolution. Kelly, your insight into CMC and the incredible work that you lead show how far the CMC has come and the challenges and opportunities that lie ahead for all of us in the field of mediation. To the families and friends of the graduates, thank you for your support and ensuring that these graduates gave the best, and your sacrifice is exemplary. The Robic and the loyalty company, Davis and the Reverend Pro, thank you for being accommodating and welcome with us on our first graduation ceremony. To the staff at the Westminster Central Bank, thank you for being generous and flexible as we navigate this unique event. And finally, the graduation organizing committee. Your hard work and long hours has brought us here together, and this event would not be possible without Rohit, Mr. Ash and Ash, Leona, Ketan, Kavina, and Frey Brian. Ladies and gentlemen, we thank again for being with us and celebrating success. I now formally close the graduation ceremony on the 19th of March 2025.
And now I kindly ask everyone to rise for the faculty reception. So, firstly, as we come to the conclusion of this occasion, I want to take a moment to once again congratulate each one of you and thank you so much for being patient with us throughout this day. I request all the graduates to be seated. We are going to do a group photograph. All the guests, please wait outside and the graduates will be with you soon. Thank you so much.